Good morning, Chief.
Good morning, Commissioner Byrd. Let me mute my volume on this other hearing I got going. How are you?
I'm good. How are you?
I'm okay.
Good.
It's been a busy week. We have the Rocky Mountain ambulance case hearing going on since Monday morning, so.
I wouldn't have thought it'd take this long, but I guess it's good. It's thorough.
Yeah, it was scheduled for all week actually, but it appears we've made some pretty good progress, and we're hopeful it'll adjourn today.
Yeah. Good morning, Commissioner Maestas.
Commissioner Byrd, good morning to you.
How are you doing?
I'm doing good.
Good.
Hey, that picture that you have there, is that your ranch, or what is, it looks like some grassy land there.
It's the wheat field next to my home.
Oh, okay.
So that's what I'm looking at when I'm sitting here talking to you.
Okay. Just wondering,
Yes, sir.
how is the ranch?
We're starting to dry out, but it's misting right now, so there's hope yet.
You're gonna have to
Otherwise, we're good.
do a rain dance or something there, guy, to
Yeah,
Get some
right
more
now is the
precip.
time to do it because it'd be effective right now.
yeah. Well, I grew up on a small farm, and we had acequia water, and
Yeah,
that was when water was plentiful.
so we thought.
I still have acequia water rights there because I still own the land, but I have been putting it to beneficial use, so I banked it.
Yeah,
But there's been no interest in leasing my water rights.
really.
Yeah.
Why would that be? This is Steve.
Guy, I think so.
Good morning, Commissioner.
Good morning.
Good morning, Mr. Chairman. So much of the farmland there in the Santa Cruz Valley has been fallowed, and a lot of people have banked their water rights just as I have, and so there's a pretty long queue. But yeah, at least they liberalized, they use it or lose it, right, with regard to water rights, and so I'm able to at least bank them and preserve them as long as I pay my dues.
Your assessment, yeah.
Yeah.
Well, that's good.
Was that good, Mr. Chair?
Already hitting the heart stuff.
I guess so. That was.
What's that?
I mean, I love my coffee, but.
Oh, did you hear me sigh? And my throat was dry. I needed that badly.
Good morning.
Morning.
Good morning, Commissioner Hall.
Good morning, Commissioner Hall.
How is everybody?
We're good.
Good.
And I think Commissioner Vicente Aguilar's on too.
Yes, good morning.
Good morning.
Hey, good.
Good morning, Commissioner Vicente Aguilar.
Boy, I guess we're ready to go here. Let me see. Yeah, Judy's on here. Judy, will you say the pledge for us? Maybe not. Okay, I'm going to go over to Jason then. Montoya.
Good morning, Mr. Chairman, Commissioners. Thank you.
Morning.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
Thank you, Jason. And Commissioner Byrd, you're still the all-time champ on the pledge, so I think I might make you the permanent pledger.
I'll do better next time.
No, you can't do better. You do great. So anyway, consideration and approval of the agenda.
So moved.
I'll second that.
Second.
Yeah, so Commissioner Byrd moved. I got the second. I was first. Mike, can you please call the roll?
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
The agenda is approved by a vote of 5-0.
Terrific. Introduction of special guests.
Mr. Chairman, this is Jason. I don't have anybody signed up for that agenda item today.
Okay, then let's go on to public comment.
Mr. Chairman, we don't have anybody signed up for public comment either.
Okay. Item 5, consideration and potential approval of contracts over 20K. And Jason, I guess you're going to speak to this one?
Actually, Mr. Chairman, I was going to give the floor over to Mr. Jim Williamson. I don't know that he's on. Jim, if you're on, could you please, I don't see him here. But basically, Mr. Chairman, this is just the due process. I know that I've worked with ASD and the Fire Marshal's Office. I'm sorry, this is the State Rural Universal Service Fund, Utilities Division. I think this is the one that went out for RFP. John Reynolds, are you on the call or Mike Ripperger? Let me see if I can get a hold. Sorry. Give me 1 second, Mr. Chairman, sorry.
Okay.
Good morning, Mr. Chair and Commissioners. The contract before you is for the approval of a contract for the auditor of the financial statements for the Universal Service Fund, the Telecom Bureau of the Utilities Division. It does not use state funds. The RFP was processed in an open manner, and that is the recommended bid by the committee, the RFP committee, to award the contract to Hulbert CPA. And if Mr. Ripberger has any additional information regarding the telecom, he's welcome to input. Thank you.
And Mr. Chairman, thanks, Jim. And Mr. Chairman, this is on the agenda because if you recall, the resolution that we approved, the commission approved, established a threshold of 20,000 for agency head approval.
Correct. And just to be clear, this is an auditing contract for the folks who administer our SR USF fund, correct?
Yes, sir.
Okay. And I do have one question, is it's for all the years, it's for 4 years, 2018 through 21. Is there a reason that we do 4 years together, that we don't do an annual auditing contract?
Mr. Chairman, Commissioners, Commissioner Fishman, if I could answer that question. What happened was the auditor got to 2017, and at that point we could probably either renew, which we had done before of a prior contract, or put it out for bid. We were late putting it out for bid. Those years account for the years that have not yet been audited. And I believe they reflect the same years as the contract for the current State Universal Service Fund administrator. So they would go with those. And so when you do an audit of prior years, you don't need to do it that year. You need to just be able to have and access all of the paperwork for those years that are available. So we're catching up a little bit, but with this contract, what's written into the contract is that they can do these each year on a 6-month cycle. So they can take care of one audit year over 6 months and go through that audit, and then do another one for 6 months and another, and then another, and we'll be caught up. And hopefully we can synchronize the audit timeline with the contract for the administrator of the State Universal Service Fund.
Okay, so this is intended to be annual going forward?
Yes.
After we catch up?
Yes, and then Then there'll be an issuance of another RFP for 4 audit years going forward when the new, when the next bid for the administrator of the State Universal Service Fund goes out.
Okay. Any other comments, questions from the commission?
Mr. Chair, so this audit, since it doesn't involve state public funds, doesn't have to go to the state auditor for approval, or you know, how is it different from the auditing of a legal subdivision of the government and the involvement of the state auditor?
Mr. Chair, Commissioner Maestas, that's correct. These aren't public funds per se, so it does not require approval by GSD or the state auditor, but we did contact them just for their guidance and advice to make sure everything was in an open procurement manner. But you know, just to follow the best practices. So, but that is not under the jurisdiction of the state auditor, correct?
Thank you. And then, Mr. Chair, my last question is, there is an advisory board to the Universal Service Fund manager. Do they have any involvement in the audit, in the entrance conference, the exit conference, or is their role, you know, completely independent of this audit?
Mr. Chairman, Commissioner Maestas, the audit, the State Universal Service Fund Administrator interfaces with many of the members of the State Universal Service Fund Advisory Board companies. And so they're collecting monies from them, distributing monies to them. So probably not appropriate, I would think, to have a lot of them involved in that process. We would probably want that to be independent of that, so there's no seeming any impropriety.
Okay, is that explicit in their roles and responsibilities of the advisory board? Do we consciously separate that wall between the advisory board and the fund manager administrator?
Well, the advisory board, according to the rule, the advisory board is to be composed of many carriers and another consumer group. So by nature of the board, they're going to be on there. Their function is to provide advice to the commission on matters that come up before the commission on State Universal Service Fund issues. And but in order to oversee what's happening with the administrator, the administrator is on the calls monthly. They provide financials. There is feedback to get an understanding from the advisory board members about what is actually transpiring with the operation of the fund. And if there's any commission actions which have affected the fund, and getting that feedback from the administrator. But they don't tell the administrator how to do their job, so to speak. They sort of give feedback or discuss things with them, but it's not a, you know, the administrator answers to the commission primarily.
Thank you for that. And I guess, you know, Mr. Chair, I would kind of echo your initial comments that I think if we were a legal subdivision of the government and we were behind, you know, four fiscal years in our audits, we would not be in good standing. And so I think going forward, I think it'd be much more prudent for us to stay current on these audits. That's all I had, Mr. Chair.
Any other commissioner comments, questions? Okay, I believe we need to take a vote on this.
Move to approve.
I'll second. Commissioner Maestas moved to approve. Mike, would you call the roll?
Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas.
Aye.
The contract is approved by a vote of 5-0.
Okay, thank you, Mike and Jim, for getting us on the road to catching up on this one. Consideration and approval of prior meeting minutes.
So moved.
Second.
Second.
Okay, Commissioner Byrd moves, Commissioner Hall seconded. Mike, can you take the roll?
Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall.
Aye.
The open meeting minutes are approved by a vote of 5-0.
Okay, on to consent action items.
Mr. Chair,
Yes, Commissioner Hall.
you know, there was one item that I wanted to discuss just for a minute. If we could pull item 20-00104 to the regular action items. I just wanted to discuss a timing issue in that case, having to do with the deadlines that Russell mentioned in his memo to us.
So we're a little bit out of order there, Mike. Is it okay if we move that at this point in the agenda?
Commissioner, I guess we treat that as a late motion to change the agenda. So it would take that would be the motion, and there should be a second, and the commission can vote to do that.
Okay, so Commissioner Hall, you've made a motion to
Yes,
move the item out of consent.
yes.
Okay, and I'll second that. And Mike, do you want to take the roll on that?
Sure. Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar.
Aye.
The motion passes 5-0.
Okay. Is there a motion to pass the remainder of the consent items?
So moved.
Second.
We got a motion from Commissioner Byrd, a second from Commissioner Maestas. Mike, take the roll.
Let me find my place here. Pardon me. Commissioners, this is a vote on consent action items, which are comprised of cases 21-00054TRM in the matter of the application of North Star Moving Corporation, DBA North Star Moving Company, for a certificate to provide household goods services. This is a potential order regarding the application for certificate. There is next case 21-00062TRM in the matter of the application of Casa Healthcare LLC, DBA Home Care for the 21st Century for a certificate to provide non-emergency medical transport service. This is a potential order regarding application for certificate. Utility matters are case 19-00154UT in the matter of the verified petition of Plateau Telecommunications as a competitive local exchange carrier for designation as an eligible telecommunications carrier for limited purposes. This is a potential order regarding second phase recommended decision. Case 21-00016UT in the matter of ETC designations for federal rural digital opportunity fund grantees. And this is a mouthful. Potential procedural order concerning pending applications/petition dockets and concerning applications/petitions not filed at this time. A potential order appointing Hans Mueller and Russell Fisk as hearing examiners for the pending and future applications/petitions, a potential order authorizing hearing examiners to effectuate the procedural order issued in the docket by issuing orders in the respective pending and future dockets. And then case 20-00104 UT has been removed. So this would be a vote on those items. I'll call the roll. Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall.
Aye.
Consent action items are approved by a vote of 5-0.
Okay, we're on to regular action items, but let's take item 104. El Paso Electric, Commissioner Hall, you had some issues.
Yes. Well, I think it'd be good if Russell just presented it briefly, and then I'll express my issue.
All right, Mr. Chair, commissioners, can you hear me?
Yes.
Yes.
Okay, so this is, of course, on the agenda for an extension of time with regard to the El Paso Electric rate case to the maximum amount of time allowed under the Public Utility Act for consideration of a rate case, which is 12 months, 1 year. Currently, the deadline that we have is May 16th. And that is an extended deadline because that was extended, I believe, 46 days from what would have been the 9-month deadline. That was extended by the commission in a previous order at the request of the hearing examiner, Carolyn Glick, because she had to vacate the hearing due to the fact that she needed additional information, and she then rescheduled it. So there has been an extension, but only to May 16th. And I will certainly need more time. As you know, the RD was just issued last week. It runs to 308 pages. That's without exhibits. You know, the hearing examiner asked me if I wanted the time for exceptions and responses to exceptions shortened from the time given in our rules. And I said no. I said this is a rate case. These are you know, the 13 and I think it's 13 days for exceptions and 8 days for responses, I believe, or is it 9, something like that, is, you know, it's going to be needed for a rate case. So the exceptions are due April 19th. Responses to those are due April 28th. Must be 13 and 9 days, I guess. Anyhow, so you can see why time will be needed to review those, what I assume will be substantial exceptions and substantial responses, in addition to reviewing and analyzing the 308-page RD itself. So the fully extended 12-month period would give the commission until June 28th to issue final order, and the last regularly scheduled open meeting before that date is June 23rd. Obviously, I do not plan on bringing this rate case just on the last day, June 23rd. I'm hoping to bring it the third open meeting before that, to give 3 open meetings, because as you know, with a rate case, not only are there a lot of issues to consider, but if rates need to be redone, or then that has to go back to a committee of experts, of the expert witnesses, to redo all the numbers. So like at one open meeting, the commission might decide you want to see rates rerun with some different assumptions, or with some different allocations, and that can take quite a bit of time. So with that, I'll just turn it over to you, commissioners, for any questions.
Well, okay, Mr. Chair.
Yes, Commissioner Hall.
Okay, I guess I didn't realize that Carolyn's recommended decision came out on the 6th. I just saw it in my email yesterday. I must have missed it before. So I was concerned that there was a shorter period of time for exceptions. 13 days is better than what I thought it was, which was much less, because I thought it had come out just this more recently. I don't know, I guess just a couple of days ago. So I guess this schedule is fine. My main concern was that the parties would have not enough to review a 300-page opinion and write exceptions in what would have been maybe less than a week. But if they've got 13 days, I guess that's better. I still was a little concerned about that, but that's close to 2 weeks. That's a big decision though. But I do agree with Russell that it would be nice to have 3 open meetings. It would be good to have 3 open meetings on a matter that large. So I think I'm okay with this now that I understand the real scheduling. I'm fine with this.
And Commissioner Hall, can I just add? Oops, I heard
Yes.
a voice.
Yes.
Oh, maybe it would echo. Oh, I just had one thing to add. I did get a call from Paso Electric on Friday, just asking about this item on the agenda and what it was, and they said they might file a motion for an extension of time and the exceptions, but I don't know. They weren't certain about that, so they might be asking for more time on exceptions.
Yeah.
Okay.
Okay. All right. Well, thank you very much.
And,
That was my only concern.
and my comment there, Russell, is whatever needs to happen in terms of giving people enough time to do the exceptions, because there are a lot of issues in the case. We really do need to hold sacrosanct that idea of having three bites at the apple in terms of the open meeting, just because there are so many issues. And I think Carolyn's done a terrific job with this one, but there's just so many issues there to review that let's be sure we don't get the commission squeezed on its decision making.
Yes, Mr. Chairman, I'm shooting for that. I think we'll be able to do that. And like I said, the committee of experts, it could take them some time to do various iterations of the numbers of the rates if the commission has requests like that. So we need to build in time for that too. And I think three open meetings will do that.
Okay. Any other commissioner comments? Okay. On to our regular action items. We've got.
Well, Mr. Chair, do you need to vote on this? Was this included? I don't think this was included.
Yeah, I guess we do need a vote. Thank you. I'm sorry. Mike, well, first of all, Commissioner Hall, I'm going to move this. Are you going to second it?
Yes, second.
Okay. Mike, call the roll.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Byrd.
Aye.
The order passes by a vote of 5-0.
Okay. Now we're on to case 19-296 in the matter of potential amendments to Rule 17-9572, Renewable Energy for Electric Utilities. And Judith, please help us out.
Yes, good morning, Commissioner Fishman, Chairman, and members of the commission. This matter comes before you again this week in case number 19-296, the potential amendments to the Renewable Energy Act rule. Based upon the discussion last week after I read the final rule amendments, I made changes to the rule that I was instructed to make. And it was my understanding at that time that the commission wanted to move certain outstanding issues to the docket number case 20-00158 UT. However, subsequent to the meeting, a couple of commissioners independently mentioned to me that they would be open to not keeping the docket open for another 2 weeks and voting on a final rule either this week or next week. And so I have 3 proposed orders that could be adopted by the commission. The first one would be to do what was discussed last week, which is reopen the record in the rulemaking for 2 weeks for the outstanding issues to be briefed. If that happened, we would have to change the filing schedule of the utilities. Right now, EPE's filing is due on May 1st, PNM June 1st, SPS July 1. The statute has a July 1 deadline, so that is not able to be changed, but the staggering could be changed by the commission as long as everyone filed by July 1. The outstanding issues that commissioners wanted to reopen the record for, I wrote down, what does the phrase capital investment opportunities used in 6216 mean in terms of the definition of financial incentive? Then Commissioner Maestas had several kind of related issues related to the 100% zero carbon standard in 2047. Does that include the 80% renewables that the utilities were required to meet in 2040? And does that limit nuclear resources to 20%? And then there was an issue about whether the financial incentive might be able to incentivize closure of the Four Corners facility, and could a non-regulated entity such as Arizona Public Service apply for a financial incentive? So at this time, I think the first decision the commission needs to make is whether to reopen the record for 2 weeks for those outstanding issues and change the stagger schedule for the filings. If you decide not to do that, then you would need to decide whether to move those issues to case number 20-00158. And then after that, you would have to decide whether you wanted to adopt the final rule today or bring it back next week. Either way, we have to publish it by April 22nd or submit it to the register by April 22nd in order to get it published by May 4th so that we don't have to change the stagger schedule.
Okay, is that everything you were going to present, Judy?
Yes. So as I said, first decision whether to move the issues to case number 20-00158 or reopen the record for 2 weeks to have those outstanding issues briefed at this time.
So commissioner comments and questions.
Mr. Chair, Judy, can you clarify that the issue of defining capital investment opportunities has been addressed in the revision that's being displayed?
No, it hasn't. We still haven't fleshed that out.
Okay. Well, Mr. Chairman, I support option 2, which is adopt the final rule today and move the outstanding issues to the other part of this bifurcated case, case 20-158. that would be my preference.
Personally, I agree. Yeah, I have my new assistant on board, Robert Lundin, and I think he can kind of take on the, what is it, 158? Is that the number, Judy?
Yes, 20-00158.
So
Right.
I think we can get underway on those outstanding issues pretty quickly. And I don't think it pushes too much onto that docket. And I think it certainly supports our staff and our hearing examiners in terms of keeping some sanity on their schedule. So,
Mr. Chair,
I concur.
Mr.
Yeah,
Chair.
Commissioner Hall.
Well, if there's no further discussion, I would move the order.
So we've got
Second.
a first and a second from Commissioner Maestas. And Mike, would you like to take the roll?
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas.
Aye.
The order is approved by a vote of 5-0.
Next, we would need to, if the commission chose to adopt the final rule today, I would like to go through a few of the changes I made as directed last week. If the commission does not want to adopt the final rule today, we can bring it back next week.
Mr. Chair,
Yes, Commissioner Maestas.
just a point of clarification. I thought the order addresses the approval of the final rule.
Mr.
Well,
Chairman, that was my
that might-
mistake. I'm sorry. I thought that was being addressed at the vote.
I thought that was just a motion to move the outstanding issues to 2158. But if it was,
Yes, that's what I thought I was moving. But
Mr. Chairman, Commissioners, I was going to clarify that I misspoke when I said order. It should have been the motion.
I was on board. If commissioners all feel they know what they voted on, that we simply move to push those issues, outstanding issues, to 158. That's all that our last vote did. Any
Mr. Chairman,
confusion on that? Go ahead.
Mr. Chairman, I heard from Commissioner Maestas he made a motion for final order, finalize the order, and to move the issues to case number 20-158. That's what I heard.
Okay,
And
so
that's what I voted on.
So let's go back to the motions and let's get clear. By the way, I'm fine moving both together and taking one vote, as long as we have to revisit this.
And Mr. Chair?
Yeah, go ahead, Commissioner Hall.
So I made the motion. I made the motion. And I said I would move the order, now that I recall. But so my intention was to simply move what Judy was proposing, which I guess was just a motion on, I know was a motion on moving these items to the other case. I thought that was where we were procedurally.
Okay.
But
You want to redo the motion, Cynthia, and include both? And better?
Unless others want to discuss whether or not to move the order this week or next, but I guess
Mr.
I'm
Chair.
fine with it. Yes, go ahead.
Just as presented in Judy's memo, I supported option 2, which is the
Right.
kitchen sink version, which is approve the final rule as presented today and move the outstanding issues to 20-00158.
Yeah, I understood that too. So I'm willing to make a actually, what I uttered was the right thing, that I would move the order. And the order would be to move the items to the other case, and also to approve the order today for approving the rule today rather than next week.
Okay, so is that what you're moving, Commissioner Hall?
Yes.
Okay. Do I have a second?
As a seconder, I accept that.
Okay. Mike, let's try it one more time and get this clear for the record.
Commissioner Hall,
Aye.
Commissioner Berg,
Still aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Maestas.
Aye, aye, aye.
Yeah, there you go. That sounds like all the
Yeah, we haven't heard that in a couple months.
Yeah, exactly.
And the vote is 5-0, and I'm not going to characterize it.
Thank you for that, Mike. Okay, Jason, I think we're on to the next agenda item.
The next agenda item
Okay, here
is,
we are. Okay, I just needed to see the agenda here. So we're on to item 21-84 in the matter of the application of Arroyo Solar, Arroyo Storage, and Public Service Company of New Mexico for expedited location approval of the Pintado Switchyard in McKinley County, New Mexico. Judith, this is yours again.
yes, last Friday on April 9th, 2021, the applicants, who are the Arroyo Solar LLC and Arroyo Storage LLC, together will be referred to as Arroyo, and Public Service Company of New Mexico, PNM, filed an expedited application with the commission pursuant to 6293 NMSA 1978 and the Commission Rule 17.9.592 for location approval of the Pintado Switchyard. The application requests Commission grant expedited approval by July 1, 2021, in order for the Pintado Switchyard to be completed in time to transmit energy from the adjacent Arroyo project to PNM's existing grid, and to enable the Arroyo project to achieve a commercial operation date of June 30th, 2022, which is the retirement date of the San Juan Generating Station. The application explained that the 8.7 acre Pintado Switchyard will be sited within a 14.7 acre parcel that will ultimately be owned by PNM, but presently is owned by Arroyo, and will connect the Arroyo project via a 500-foot transmission gen-tie line from the switchyard to the Arroyo substation. PNM will interconnect the switchyard to the existing Four Corners Rio Puerco 345 kV transmission line via 2 tap lines. The application states that the facilities included in the switchyard include the terminus of those 2 tap lines and a short span of PNM's tap lines that are wholly within PNM property. Hold on. The application also explains that the Arroyo project previously received commission approval in case number 19-00195 UT as part of a portfolio of resources to replace PNM's portion of the San Juan plant. In case number 20-00182 UT, there was approval of a power purchase agreement, energy storage agreement, and other agreements between Arroyo and PNM. And then most recently, in case number 20-00188 UT, the commission approved the location of the Arroyo project's solar generation and energy storage facilities, the Arroyo substation, and the Gentie line connecting the Arroyo substation to the switchyard. The application states that neither the switchyard nor the PNM tap lines or terminus into the switchyard were included in the location approval application in case number 20-188. Arroyo states that the reason was that at the time, Arroyo understood the switchyard and the PNM tap lines did not need commission location approval due to the commission's safe harbor provisions of 17.9.59215 NMAC and or pursuant to NMSA 1978, section 6293D did not require location approval because they would be, quote, additions or modifications to PNM's existing facilities. However, the applicants state that after deliberations at the March 3rd, 2021 open meeting during case 20-00188, uncertainty was raised regarding whether the switchyard met the criteria to be safe harbor. And the final order in 2188 expressly limited location approval solely to the Arroyo Solar and Storage Project and the substation and the Gentie line. For those reasons, the application states that for the avoidance of doubt and to provide permitting and financing certainty for the Arroyo project, and to the extent such approval may be required, it requests location approval of the switchyard and the short span of PNM's tap lines located wholly within the PNM property and the terminus of the tap lines wholly within the switchyard property. They state that the approval request is expedited based upon a commercial operation date of June 2022. Attached to the application was a proposed form of notice, and the proposed order would commence a proceeding, partially, grant the request for expedited action as set forth, that applicants should publish notice as soon as possible in the Albuquerque Journal, which is a newspaper of general circulation in McKinley County. That the procedural schedule would be that they would applicants would immediately post notice on their websites. Then they would file affidavits of publication. Interveners would have, or protesters would have 60 days to, according to the statute, to file a motion for leave to intervene or a protest. That would be June 16th, 2021. The commission's utility division staff and any intervener may file direct testimony on June 17th, rebuttal testimony on June 18th. A proposed final order would be filed by the applicants on June 18th. If there were no protesters by June or interventions filed by June 16th, the commission may determine by the commission or subsequent single signature order that a public hearing is not necessary. However, if a public hearing is deemed necessary by the commission, that it would be held at the commission's open meeting on June 23rd to be presided over by the commission or by a designated presiding officer that would be appointed by a subsequent single signature order. And the procedural dates and requirements, as I just described, would be subject to further modification by order of the commission. And with that, I stand for questions.
Commissioners,
Mr. Chair,
go ahead, Commissioner Maestas.
for the purposes of discussion, I'll move to approve the proposed or potential order.
I'll second.
Mr. Chair,
Go ahead, Commissioner
if I
Maestas.
may, first of all, I just want to thank the joint applicants, Arroyo and PNM, for following up on the discussion and the uncertainty regarding the situation regarding the switchyard and whether or not it falls under the safe harbor rule. Perhaps this should have been initiated from the get-go as a joint application to address all the facilities. And I still feel, so I acknowledge and support this expedited procedure. I don't think we should, further delay the construction of this because we are bumping up to the ultimate operational deadline, for this project, which has been the subject of a wide array of approvals leading up to this meeting. And so that's not my intent to delay it. However, I stand by my position that the switchyard's application to the rule was ambiguous, and I still question the definition of existing right-of-way to include the 1,200 feet around the brand new easement obtained for the tap lines. And so again, I reiterate the need to revisit the 440 rule, and in conjunction with the location approval rule. I realize we can't change the statute, but we are going to see very different projects than perhaps what location approval envisioned. You had a generation plant and tap lines, but now with these renewable energy projects that have storage facilities that include build transfer, where you have one applicant building and transferring it to another entity, we need to make sure that it reflects these new kinds of new projects, and that we avoid piecemealing these projects based on the application of different rules. A new project is a new project, and I think we're obligated to look at the totality of the environmental or potential environmental impairment. And I'll conclude by one of the big changes, in this application, Mr. Chair, is that it included an environmental report on the switchyard, a contingency plan should any archaeological artifacts be encountered during the construction of the switchyard. Construction would be stopped, and of course, that wasn't in the original application. And so I think this advances and meets the full spirit of the location approval law, aside from the 440 rule. So again, I want to thank the joint applicants and appreciate their responsiveness to our concerns. Thank you, Mr. Chair.
Thank you. Other commissioners? Okay,
Mr.
we
Chairman.
have, go ahead, Commissioner Vicente Aguilar.
Yes, thank you very much. I need clarification from Judy. With this procedural order, does it include public hearing? You stated in your short presentation this morning that if the commissioners wish to go through the public hearing, so I need clarification on that.
Yes, Commissioner Vicente Aguilar. The proposed order states that the commission after June 16th, 2021, could decide to hold a hearing on June 23rd, 2021. They could, the commission could decide to do that on its own motion. The commission could decide to do that if there were protests or even if there weren't protests. But if there were no protests, then a public hearing would not be required, but the commission could choose to have it on June 23rd. Did that answer your question?
Yes, thank you very much. Mr. Chairman, what I would like to insert in the order, the procedural order today, is to go ahead with the public hearing. It's located in McKinley County, and I would like my constituents and elected leaders to weigh in on that. I want to open that up if it's possible, Mr. Chairman. Thank you.
Okay. So Commissioner Vicente Aguilar, I want to get a little more clear on what you're asking. You'd like to hold the hearing in McKinley County?
No, Mr. Chairman, because of the health order, it's going to be virtual. Just think my constituents and elected leaders, they can call in during the open meeting.
Okay.
So I do want to open up for a public hearing in that perspective.
Okay. So I'm going to ask staff here real quickly. Jason, Mike, is there anything special that we need to do to accomplish that other than maybe do a little bit of extra work to notify folks in McKinley County that this is coming up and they can participate?
Mike, you want to go first? I'm not sure if you have anything to add. I was just going to make some suggestions.
I mean, it's I guess the question really is probably directed more Judy in terms of the public notice that you've provided. Would that be adequate to put the people in McKinley County on notice, Judy, or would there be additional?
In terms of notice of the public hearing, right now, it is in the Albuquerque Journal and on the websites. So I think that that would not be, and then it'll be, if we had a public hearing, it would be posted on our agenda and on our website. Further notice could be added by the commission, such as P&M providing bill stuffers, P&M posting it on their webpage. I can't think of any other manner of providing it.
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
And maybe this is good information for the General Counsel's office as well. Albuquerque Journal is limited in McKinley County. Websites, we are way behind in broadband in McKinley County. That's why I'm very stern with the telecommunication companies about broadband. We were crushed during the pandemic. So people do not have internet service, especially at the location that we are going to approve on this particular case. That's the reason why I would like to personally write letters to our county managers, McKinley County Commission, and many leaders in that in Northwest New Mexico. I can provide the names and the email addresses, but I just feel that my constituents are left out of the process.
Mr. Go ahead, Mike.
I was just going to suggest that the local newspaper in Gallup might be an option as for publication.
I think for purposes of satisfying the 60-day notice that that the whole schedule is based upon, I was informed that in terms of notice of the proceeding, the Albuquerque the Albuquerque Journal would have publication in the next few days, but that the Gallup Sun couldn't do it right away. But I think the Gallup Sun could provide notice of the public hearing. And in terms of a public hearing, we're not locked into a 60-day notice. So I think the applicants should post notice in the Albuquerque Journal and the Gallup Sun. And as Commissioner Vicente Aguilar said, provide letters to the county commission and all the cities and tribal entities located within the county.
I'd point out that legal notice is not something that the general public would tend to see in a newspaper, so that the notice that's put into the Gallup newspaper might be more along the lines of upcoming events, and that it's much more likely to get read by the general public there than in official legal notices. So that was just something pointing out to you, Commissioner Vicente Aguilar, that in terms of what kind of thing we ask to get published.
Thank you, Mr. Chairman, and thank you very much for your feedback, Judy. It's Gallup Independent. That is the local newspaper. That's the official local newspaper. There's also the Navajo Times and Farmington Daily Times. So those are the three top newspapers that people read. So my assistant has all the email addresses for the county officials in McKinley County, San Juan County, Sandoval County. So if that's okay with my colleagues, I would like to ask if that can be submitted to the General Counsel's office so that letters can be sent out.
Commissioner Vicente Aguilar and members of the commission, I just would like to clarify that the legal notice would be in the Albuquerque Journal, because that could be done right away and we could get the 60 days started for purposes of the statute and for purposes of the expedited process. The other notices could be, as Commissioner Fishman was describing, more of upcoming event type notices, but not for purposes of the legal notice and starting the expedited process. Does that make sense? Because if you're trying to get the legal notice in these other newspapers, that will have to change the entire expedited schedule, which the whole application is predicated on publication an Albuquerque Journal by, I think it's either April 14th, 15th, or 16th, one of those days, and then starting the 60-day at that time. Does that clarify the expedited process nature of the case?
Yes, Mr. Chairman, that is true. I understand, and I would like to accept Judy's recommendation. Thank you.
Okay, now do we need to do any kind of friendly amendment for this, or is this something that we can just do less formally behind the scenes? Michael?
I think that's a question for the, I forgot now who made the motion and seconded it, but I
I
think,
made the motion.
I think it does substantially alter the original motion.
Yes, someone would have to make a substitute friendly amendment and specifically stating that the applicants will write letters to the McKinley County Commission and the city officials and the tribal officials located within McKinley County. And that in the upcoming events sections of the Gallup Independent, Navajo Times, and Farmington Daily Times, that the applicants will provide a notice in the upcoming events section of those papers.
So Commissioner Maestas, are you okay with that?
Yeah, I'm fine with that amendment.
Commissioner Hall?
Well, that's fine. I thought Judy said someone would have to make a motion for an amendment.
Yeah.
If we haven't had a motion, I'll make it.
Yeah.
Okay.
So we have a motion from Commissioner Hall, and I'll ask Commissioner Vicente Aguilar, do you want to second that? Does that cover your needs?
Yes, I will second. Yes, I will second that.
Okay, so we have a motion from Commissioner Hall, a second from Commissioner Vicente Aguilar for the amendment as described by Judy. And Mike, can you take the roll?
Mr. Chair.
Oh, I'm sorry, Commissioner Burke, go ahead.
That's okay. Just a little discussion, just clarification for me. Does this
Sure.
mean that we're going to do a hearing whether there's a protest or not?
You know, Commissioner Byrd, you're right. That should also be included in the amended motion if the commission would like, because Commissioner Vicente Aguilar did request that there would be a hearing on June 23rd regardless.
So it's if there's a hearing.
So,
Thank
Mr.
you.
Chair.
Yeah.
So that's a question actually I wanted to bring up earlier, whether this hearing would be the actual opportunity that I think maybe Commissioner Vicente Aguilar was seeking for members of her tribe. So I wanted to ask her that, I guess, because this will, according to this order anyhow, the hearing will be restricted to, the participating people would be, so we restricted to the party participants, council witnesses and other representatives, and then other interested persons can view the hearing via live stream on YouTube. But I don't know if that's the accessibility that's available. So I wonder if maybe something in the nature of a more informal explanatory meeting is more along the lines of what Commissioner Vicente Aguilar feels people in the area need, or does
Mr.
she
Chair.
want them to see this formal hearing, but they would be limited to just being able to watch it on YouTube? I don't know if that really serves her purposes.
Mr. Chair.
Commissioner Maestas.
Yeah, just to clarify, I support kind of front-loaded notification of this project, which is a part of a bigger project, I might add.
Mm-hmm.
So the hearing would be limited to the switchyard only, and I'm not sure, how much benefit that would have, but I certainly do support perhaps more widespread notification of this upcoming project and the procedure. However, I believe the statute itself has language that that indicates that the trigger for a public hearing is a protest. And that protest,
Right.
yeah, I feel uncomfortable undermining the statute in this case, but I do favor Commissioner Vicente Aguilar's desire to kind of widen the net in terms of notification of this project. And so that's kind of where I stand. And that was my impression of what we're pursuing in terms of an amendment to this order. So what I'm saying is a hearing is not guaranteed, and that it would still, according to statute, be triggered by a protest.
So Commissioner Vicente Aguilar, I have a question for you is, if there is no protest and there is no hearing, would you still want an opportunity for public comment? And Judy, could we still somehow put that into this, the schedule?
Well, I have two, I just would like to read the statute language in 6293C. It says, the commission shall, after a public hearing and upon notice as the commission may prescribe, act upon the application. So that's very broad language. It sounds like the commission may prescribe a different type of public hearing, no public hearing, if there's no protest. So that being said, I mean, June 23rd, you could have a public hearing and the constituents of Commissioner Vicente Aguilar could participate, whether or not there were protests. In addition, you could, on another date between June 23rd and June 16th, during that time period, you could perhaps decide not to have a public hearing and have a public meeting. The commission has a lot of choices here.
So, but if they're not if they're not part of the docket already, then they're whatever we get out of that public hearing really cannot be central to what we do in our decision. Is that correct?
Well, as the order is written now, but you could change the order.
Mr. Chair.
And have a public hearing for the entire public and not just limited to interveners and the applicants.
And what those folks that we invite in who are not interveners say, how does that get considered in the record?
As comments.
Well, their comments, interveners can make comments that are part of the record, but non-interveners are just public comments.
So if that's the case and there is no protest, it seems to me that rather than having a hearing where it's just comments, maybe it's better to just have provide for a public comment meeting if there's going to be no hearing because there was no protest. And so would that work, Judy? And obviously, yes. Commissioner, would that work for you?
You could definitely do that. If there were no protests after the 16th, you could, it wouldn't even have to, you could, prior to the public, the open meeting or the beginning of the open meeting on June 23rd, you could have a public meeting, or you could even do it on June 22nd or June 21st.
So Commissioner Vicente Aguilar, I was just trying to get the options laid out for you there. What are your thoughts?
Well, Mr. Chairman, I think I don't want to set back the projects that have been approved by this commission. I don't want to delay it any further. but I would like to put on the record that I intend to do public service announcements at their local radio stations rather than going through the newspapers.
Okay.
And then I will also send letters on behalf of my office, and that's not going to delay the hearing schedule. So I guess that's what I should have stated from the beginning. But I think after hearing from everyone this morning, I don't see it as an obstacle. I see it more as an informational meeting or information that my constituents need to be well aware of. After all, these type of projects on renewable energy, it's good for New Mexico, and it's time for me to share the good process that we are working on here at the commission. That was the whole intent. I want to celebrate with everyone that we're moving along, and it's what the law states, and these are the projects that we have approved in early March, and I'm just proud of it. I'm proud of the work that we do. I just wanted my constituents to be informed. So I'm going to allow Judy to proceed with the procedural schedule as she proposed in the order, but in accompany to that, I'm going to provide public service announcements and also send letters to elected officials.
So thank you, Commissioner Vicente Aguilar. What I'd like to propose is, Judy, you described that we could have a kind of a public meeting or official comment period, or however we want to describe it, ahead of the June 16th meeting. Was that what you were describing?
No, I have the June 23rd meeting.
Of the open meeting, correct?
Right, the June 23rd is the date that the applicants are requesting final approval. And they are also stating that if there's a protest, that a public hearing would be held on June 23rd at the commission's meeting. Yes, what I suggested was prior to that, which would be either on the Monday or Tuesday of that week, or June 21st or June 22nd, you could have a public comment meeting where the applicants could talk about the application and the public could make comments.
Commissioner Vicente Aguilar, I just want to be sure we've done everything we can to accomplish what you're just asking about. And I would be fine with doing a meeting like that to kind of trumpet all the good things that are going on. And so if you want to include that, I'm certainly open to that. Commissioner.
Mr. Chairman?
Yeah.
Are you talking to me?
Yeah, I was talking to you.
Yes. Yes, I sometimes I think you're talking to somebody else, but well, I think we had a good discussion this morning, and Judy knows what I have in mind. The General Counsel, Michael Smith, he knows what I have in mind, and I think they just need to insert the right language in their order. That's I'll end it as that.
Okay, Judy?
Yes, I believe that Commissioner Vicente Aguilar proposed adopting the order as is. She indicated that she wanted to take on a letter to the county and the city officials and the tribes, and that she did not want a newspaper notice in the Gallup Independent or Navajo Times or Farmington Daily Times that just a radio announcement. So, but I'm a little unclear as to who is going to organize the radio announcement, whether the Commissioner Vicente Aguilar wanted to do it on her own or whether she wanted the applicants to do it. That being said, I also believe that the Commissioner wanted a public comment meeting at some point in time prior to June 23rd, between June 16th and June 23rd, where the public could come and make comments.
Commissioner Maestas, if we put in language to that effect, is that a friendly amendment?
Sure. So there's a motion to amend on the floor and then my main motion. So is there a withdrawal of the motion to amend? And it's back to my main motion and me to consider a friendly amendment? Is that where we're at?
Yes.
So, Mr. Chair, if I need to withdraw my initial friendly amendment and remove a revised friendly amendment that captures all the provisions that Judy just described, I will do so. I am doing so.
The only two parts I'm unclear on is what day the public comment meeting would be held and who is tasked with the radio announcements.
So,
Mr. Chairman?
Yes, go ahead, Commissioner.
Judy, ever since we went into this health order, I've been doing radio announcements, so I'm happy to do that. Any other questions?
And then what day would the public comment period meeting be? Would it be on June 23rd or would it be a day prior to that?
I think let's leave it to June the 23rd. My letters will go out prior to that, probably 3 weeks prior to June the 23rd.
All right, well, then I would say that if Commissioner Hall withdraws her friendly amendment and makes another friendly amendment that just changes the order to state that there will be a public comment meeting on June 23rd, where the public can make comments.
Okay, Mr. Chair, I withdraw my initial friendly amendment and submit a revised friendly amendment stating that there will be a public hearing on June 23rd.
Commissioner Hall, no, there may or may not be a public hearing. It depends on whether or not there are interveners or protesters, but that there will be a public comment.
Right. Sorry, public comment.
Meeting. Portion, right.
On the 23rd.
Okay, I will second that. And so we're voting, just to be clear, to accept the order with the amendment. So we're voting on both together. Correct, Commissioner Hall?
Correct. Yes.
Mr. Chair, I thought my motion was still on the floor to adopt the order. So this vote would be just on the amendment.
Okay,
we
can do that.
And then we would follow with.
I can only aspire to be as efficient from a parliamentary standpoint as Commissioner Maestas. So it's great to have you on board.
Well, you know, we don't trust efficient meetings, so we have situations like this.
So we'll do the. We're voting then on the amendment first.
Friendly amendment, yes.
Friendly amendment first. Michael, will you take the roll?
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
The friendly amendment passes by a vote of 5-0.
Okay. And now we're coming to the order
As amended.
as amended. And Michael, will you, we have that motion from Joe, from Commissioner Bastis and Commissioner Hall seconded. And Mike, will you please take the roll?
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
The order passes 5-0.
And I'll just personally thank Commissioner Vicente Aguilar. I think it's a great idea to give folks a chance to celebrate it. So thank you for that.
You're welcome.
So now we're on to item 8, docket number 16-276, in the matter of the application of Public Service Company of New Mexico for revision of its retail electric rates pursuant to advice notice number 533. And Michael, please take this.
Commissioners, this is not this is a pretty easy issue. This was a matter that was raised by hearing examiner Carolyn Glick, who's currently handling the El Paso Electric Company rate case, in which time of use rates have been an issue. She was previously the hearing examiner in PNM's rate case 15261, in which PNM's proposed time of use rate design was an issue. She brought this to our attention. I'll give credit where credit's due. This proposed order basically would require PNM to address time of use rate design issues in its anticipated upcoming rate case, whenever it files that, if it's later this year. And by way of background, I'll just let you know, in case 15261, which hearing examiner Glick handled, the commission considered a proposed time of use rate structure introduced by PNM. Carolyn Glick in that case noted that developing an effective time of use rate design is important and requires significant study. Nonetheless, in that case, she concluded in her recommended decision that the evidence suggests, and I'm quoting what she said, that PNM's current time of use rate design is not effective, and that its proposed time of use rate design would not be any more effective. The hearing examiner in that case recommended that there be no change in PNM's time of use rate design, but instead recommended appointment of a facilitator to meet with PNM and interested parties to discuss proposals for an effective time of use rate design. As a result, in the final order in that case, the commission ordered William Herman, to be appointed as the facilitator to meet with PNM and interested parties to discuss proposals for an effective time of use rate design and promptly set a date for the first meeting. Mr. Herman, for those who are not familiar, was the previous chief hearing examiner who has since retired. Filings in the case indicate that the PNM and interested parties did meet with Mr. Herman proposals for an effective time of use rate design in accordance with the final order. However, those discussions did not result in an agreement on an effective time of use rate design. Subsequently, in PNM's next rate case, which is under this caption, 16276 UT, a modified revised stipulation was ultimately approved, which included paragraph 27, a provision stating that PNM's existing time of use periods and rates and non-time of use energy rates for residential and small power rate schedules have been the subject of a mediated process in accordance with the commission's final order in case 15261. And the signatories agree that this mediation should continue. Within 60 days of the final order in this case, PNM shall request that the designated mediator convene interested persons to receive input and to develop information relevant to time of use and options for time of use design elements such as on and off peak periods and seasonal differentials. PNM shall propose a mediation schedule that allows for the results of the mediation to be included in PNM's next general rate case. At this time, it's unclear whether the signatories to that modified revised stipulations continued the discussions concerning time of use rate design that were required under paragraph 27. From the pleadings and basically upon information and belief, it doesn't appear that PNM or the signatories have requested continued mediation of time of use rates through the mediator as contemplated. And therefore, because the commission believes that the development of an effective time of use rate design remains important, and time of use rate design has been a significant issue in El Paso Electric Company's current pending general rate case, the commission believes it is critical that an effective time of use rate design be proposed and adopted in PNM's next general rate case. Therefore, the order would propose that in its next general rate case, PNM should propose any time of use rate design or components of a time of use rate design that may have been agreed upon as a result of the mediation process required by paragraph 27 of the modified revised stipulation, if those the mediation process actually took place. If that mediation did not produce such an agreed upon time of use rate design, or the mediation did not occur, PNM should then propose an effective time of use rate design in its next general rate case. To the extent PNM does not do so, it should provide sufficient evidence to allow the commission to approve an effective time of use rate design. The ordering paragraphs in the proposed order are very specific about the content of PNM's pre-filed testimony that it should provide, and this was developed with by hearing examiner Glick based on her experience with the prior case 15261 and PNM's rate structure and the time of use rate issues that were at issue in that case. So this is basically a order that is intended to save everybody time by putting PNM on notice that this issue is not dead and that this issue needs to be addressed in its next rate case. Any questions?
Yeah, Mr. Chair, I have a question.
Commissioner Hall.
Well, I just first want to say I really appreciate Carolyn raising this issue. I agree the time of use rates really needs a close look. And it looks like from what you read, Michael, that the burden was on PNM to request a mediator to convene interested persons. I just wondered why you were saying it doesn't appear that PNM and the other signatories, it doesn't look like the burden was on signatories anyhow, the other signatories, it was on PNM. So I think it's a good thing to require PNM to explain what happened. And I also guess I want to have you clarify, but it looks to me like if they say they haven't done any mediation, then they're just required to file testimony. PNM is required to file testimony on the time of use rate issue, time of use rate design issue in the next rate case. So there won't be any mediation going on in advance of the rate case. Is that what you're intending for this to do? Because that's really, I don't think, consistent with what hearing examiner Glick was saying when she felt, well, let's see, when the stipulated agreement stated that within 60 days of the last rate case was when they were supposed to start mediation. So it seems to me, if they haven't done it for whatever reason, this order I guess, concludes that it's better to handle the time of use rate issue in a rate case rather than in mediation. Is that what is intended by this wording, Mike?
Well, I think the use rate would always be addressed it was anticipated that the time of use rate design issue would be addressed in an upcoming rate case. The intent was to have the parties get together in the interim period of time between rate cases through the mediation process to work out an effective time of use rate design.
That's what was ordered before. Yeah.
Right. So at this, and in both instances, but at this time, we're already into April, and it's anticipated that PNM is going to come in with a rate case later in the year. So at this time, it's really a matter of putting PNM on notice that this issue is going to be addressed in upcoming rate case, and that it should be proposing a rate design, time of use rate design. I'm not sure that there would be enough time with or resources between all the parties with the various cases that are out there for people to really effectively try and mediate that issue, in addition to PNM proposing that time of use rate design.
Commissioner Hall, I'll add a comment here. Is in reading the order, Carolyn has put together a very specific list of questions that need to be answered that are really crucial to doing a good TOU rate design. And they're questions that have not been addressed or answered in prior filings. And I discussed this with Carolyn at one point, and she had to go through a lot of work in the EPE case to identify those questions and be sure they got answered. So that in doing this order, we're being pretty specific about saying, give us all the relevant information that we need to do a good TOU rate design. And that really moves the ball forward for the upcoming case. So as I'm reading this order, I see that as as one of the primary benefits.
I think I printed this out all. Oh, yeah. So you're talking about questions 1 through 6?
Yes. And those are very, very detailed, specific questions that directly address good TOU rate design.
Okay, fine. That's fine. If that's what was Carolyn's objective, then that works for me.
Mr. Chairman?
Yes, Commissioner
Go ahead. Go ahead and finish. Go ahead and finish.
No, I'm done.
Well, this is a 2016 case, Mr. Chairman, and yeah, I've got maybe a greater concern about how the PRC tracks and enforces compliance with prior commitments like this.
That's an issue.
A similar issue came to light in a recent media article regarding testimony by our own John Reynolds in the PNM Avangrid merger, where certain filings were not made for the El Cabo and La Jolla facilities. And so I'd like to know how we do that. So kudos and much credit to hearing examiner Glick for raising this issue, but I think I want to know what's our systemic process for tracking these commitments from prior cases and ensuring that they're complied with. So I don't know if this is a question for Mike and or John, and maybe these two situations are just outliers, and that we do have a robust system for tracking these prior commitments. But for my own edification, I'd like to know how we track these.
Mr. Chair, I'd like to also say that was something that bothered me about this, was that this was an order, that was issued and nobody did anything. And now we are not enforcing that order. We're just saying, well, let's put it in the rate case because we don't know whether the parties have the resources to, this is the reason Mike just offered. We're not sure, we don't want to overburden interveners. That influences me a lot, but I strongly feel that it sends a bad signal when we can be talking like this about such a disregard of a duty imposed by an order and just let it go and put it into a rate case, which is what the hearing examiner advised avoiding by handling it through mediation in advance of a rate case, of the next rate case. So I guess we have to balance our interests here. And the problem is we have some uncertainty in how burdensome it will be to interveners one way or another, or parties to the case, I should say. So I guess that's our conundrum. Maybe Mike can elucidate our choices a little bit more clearly in that construct, but I find it very frustrating that it happens time and again where something is ordered and we don't follow up and we don't enforce, and important things slip through. I don't like that. I would rather, address it a little bit more head on in some way. And I don't know if that has to be ordering mediation now, maybe just imposing penalties of some sort. I'd like to know what our options are. But I don't like this continued practice of just kicking the can down the road in a way.
Commissioner Maestas, I think, asked a very clear and pointed question. How do we track this stuff?
Right.
And do we have a system? And do we need to look at creating a system? He directed that question to Mike. And so Mike, what do you got to tell us?
Well, with respect to this specific case, this was a case that after the final order was issued became the subject of an appeal to the Supreme Court, which I think delayed a lot of these things. The requested mediation it's apparent, it's believed that it did not take place because there was no filing for a mediator to be appointed as was contemplated by that. I don't know specifically whether there has not been any discussion between any of the interveners or signatories rather to the stipulation and PNM, but it appears that there has not been. And I think the delay due to the appeal may have played a part of that. With respect to the effect it has on the final, what was contemplated by the final order in this case did propose that PNM would make that the results of that mediation to be included in its next general rate case in any event. And a lot of the questions that I think Carolyn has raised here would probably have been issues that would have nonetheless been something that the hearing examiner would have wanted to address in analyzing whether the time of use rate design was effective or not. I think the intent was to try and avoid opposition to that time of use rate, proposed time of use rate design by interveners, and have something that would have been more acceptable in advance. But I think it would have still had to been analyzed by the hearing examiner in a similar fashion. With respect to how we track the requirements of the commission's final orders, our office tracks, it really depends on what the final order is requiring. we have, certain things that we require in final orders that the Office of General Counsel, addresses more directly. And then we have other issues, and this is sort of a larger issue than just a specific rate case. We have other kinds of cases in terms of transportation cases and other cases that are in front of the utilities. So some things we're aware of very directly as to whether, certain filings are made, whether the utilities are following with what was ordered in the final order. Other issues, we have to rely to some degree on staff as a compliance arm of the commission as well, as far as whether PNM is doing the things that they are supposed to do that, implicate filings, compliance filings to staff, that kind of thing. But so it's not necessarily a specific, sort of one size fits all type answer.
Commissioner Maestas, did you?
Yeah, I guess it begs for the next question is, do we have some kind of a process to close the loop? Does staff communicate with OGC and say, this compliance requirement has been met? Please take that off your tracking list. Because if staff is not communicating with OGC on these pending commitments, then we're never going to know whether they've been addressed and what the status is. And so, I don't think we should maybe discuss that right now, but I do think we need to have a discussion concentrating on that. Maybe we can address it at another meeting in terms of exactly what is the process for tracking this. I understand cases are different, but if there are commitments that are pending from older cases that have particularly a time clock associated with it, someone in the agency needs to track it, and not just when the clock expires or when the clock chimes that the time is elapsed, but we need to track it leading up to that deadline and communicate with whatever staff's involved, whether it's OGC and utility division. And so this is really just I think a fundamental process that we should have. And I guess we do have such a process, but I'm not convinced that it's foolproof and robust enough to ensure that we consistently track and ensure that these commitments are complied with.
I'm going to follow. Go ahead, Commissioner Hall.
So I think that in general, just as a rule of thumb, compliance requirements are tracked by staff if it's something in regulation, for example, if it's some kind of function that they do on a regular basis, but something that is part of an issuance of an order, I think probably more likely falls under general counsel's purview. But regardless, I just think if I were a hearing examiner and I end up writing 200 or 300 page issues, recommended decisions, I would really appreciate if there are ways of paring down the issues through parties conducting mediations outside of the whole rate case. And I can fully appreciate why this was something that was ordered. It was agreed to in a stipulated agreement, which was adopted. So that makes it an order. And I just think that we should make more. I guess I have a question to Mike. Is there a way to take a poll of the parties from the previous case to find out if they wanted to do mediation? If we can find out, what are the facts? Did they do mediation? Would they like to do it now? Would they like to do it now before the next rate case? Because as we know, even though we're anticipating a rate case being filed within a certain time frame, that doesn't always happen. So this could be hanging for quite some time, and there may well be time between now and the next rate case for parties. And if we don't ask, we'll never find out. Is there a way to find that information out, Mike?
The commission could issue, I mean, we could issue, through, I don't obviously have anything drafted at this time, but I could add or create a single signature order for one commissioner to send out, or if the commission desires an order from itself, asking the parties to respond and state whether they want to convene the contemplated mediation still at this point that was proposed in the 15261, in the 16276 case.
Then we'll know something. I suggest we do that. I don't know if we can do that in this case.
Commissioner Hall, you can do a single signature order.
Oh yeah, we can.
Between now and then, and you can just initiate that with Mike yourself. I'm going to just quickly echo what Commissioner Maestas said, and you followed on, Commissioner Hall, is quite frankly, there should be, this is something I've always worried about and I've seen in filings, is something's going to be done, but then no one really picks it up. It just kind of floats out there because we're busy with other stuff. Mm-hmm. And I think that there needs to be, if there is a list of stuff that needs to be taken care of, it's not particularly transparent or visible to all parties that should know about these things, including commissioners. And that where there are orders in cases that require follow-up, there should be some kind of a log of what those are, what the due dates are, when, that everybody can see, and that we know that they're getting followed up on or not getting followed up on. That's not the hearing examiner's job, in my opinion. I think that Commissioner Hall called it correctly. It probably belongs in OGC, maybe to some extent in staff, but that it would make sense for us as a follow-on to this to see what process there is and see how we can improve it. But that we should be able to track this stuff and make sure that it happens. Because quite frankly, a lot of the times, whenever there's a proposal to do a study or do a follow-up, my first instinct always is, no, let's not kick it down the road because it may never happen. And even if we schedule it or order it, and we need to tighten up the ship on that issue. And so I think Commissioners Maestas and Hall are dead on in their comments.
And Commissioner, Mr. Chairman, Commissioner, I guess part of one of the things I just wanted to sort of differentiate is in these final orders when we have, and this is really more an issue when we have these stipulations, because a lot of times the stipulations include a lot of provisions, or often include provisions, I should say, in which the parties to the stipulation include, I don't know how to describe it, but provisions that, benefit their specific interests as interveners in the case and are approved by the commission as part of an overall stipulation, but aren't necessarily the type of things that the commission itself would have necessarily ordered in a non-stipulation setting. And so, some of the things that are provided in these stipulations are matters that, require PNM to, meet with some of the interveners on issues and things of that nature. And they're not necessarily things that are, require the filing of a subsequent pleading or a report or something like that with the commission. So those kind of things especially become, difficult. Even staff might not even be involved in those obligations. So unless, one of the interveners who sought the inclusion of that requirement, in the stipulation files something alerting us that PNM, excuse me, I shouldn't just say PNM, but that a utility is not, living up to its obligation under the stipulation, we wouldn't really know that.
Well,
So-
I'm going to push back a little bit on that, is that if that's what we approved in the order, that's what should be happening. And if we put it on a log, for instance, it says it should be accomplished by this date, it's not that hard for us to make a call and ask, has this happened? And if it hasn't happened, we can make it an order. So,
It is in order.
but
It's in order.
my sense is that I understand the distinction you're making, but I just have to speak for myself. If I vote on something and I said yes to it, I don't care whether it's a stipulation or whatever it is, we voted on it and we approved it because we want it to happen. And so I'm more hard-assed about that, to put it bluntly. So anyway, that's my thought. Any other comments?
Mr. Chair, just I realize I kind of got us off on a tangent,
No,
but
it's okay.
I believe it's relevant. But just to end this discussion, I'd like Mike with OGC to get with John Reynolds and put together some kind of a presentation at our next meeting in terms of what our internal process is to track these commitments and how we ensure that they're enforced.
Yeah, and I agree. Let's get that on the next week's agenda.
Mr. Chairman,
Yeah, Commissioner Vicente Aguilar.
I've been listening from different perspectives. I think maybe this is something that we can assign to our new Chief of Staff, Wayne Probst, to get a breakdown of communications for every division. And don't we feel better to look at a piece of paper to see the flow chart of different cases that are being filed and orders that are approved by prior commissioners, how it's followed up, and which staff members are responsible to take on to task? Well, I think it's a larger process and a bigger project. I like to see a flow chart for every division from my perspective. Thank you, Mr. Chairman. But I don't know how you would like to lay it out as far as getting information to the commissioners. Thank you.
So again, I think that's something, Commissioner Vicente Aguilar, we can put on the agenda as part of next week's discussion. And I'm thinking a little more narrowly right now, but it certainly doesn't hurt to be looking at the larger issue there. And it is one that I agree with you, our new Chief of Staff should be focused on, and it's one that I don't think it's that complicated to at least get a tracking chart in place. It's just mostly a matter of deciding who does it and how that fits into responsibilities and how to keep it from becoming an overwhelming task, which if we're keeping up with it, each case at a time, I don't think it is an overwhelming task. We just need to have the discipline to do it. So anyway, let's keep that on, put that on the agenda for next week as well. Does that cover it, Commissioner Vicente Aguilar?
Yes, Mr. Chairman, thank you very much for giving your responses. And we're all in this together. And that's why I break in every once in a while to express my concern. But I think it's all good. Thank you. Bye-bye. Not bye-bye. just giving my input.
Hasta la vista, baby.
Oh, you wish.
Yes. Okay, with that, I would move this order. Is there a second?
I'll second it.
Second.
Any further discussion? Mike,
Wait a minute, wait a second here. I thought. This order, I believe, does relegate these questions to the rate case. And I was prepared to do a single signature order that Mike could prepare to inquire if the parties to the last case would want to, in advance of the rate case, pursue mediation.
so Commissioner Hall, I guess in making the motion, I'm saying that you can still do that. This simply requires that in the next rate case, they provide this specific information. It doesn't stop us from issuing a single signature order to say, let's do the mediation. At least that's how I see it. Mike, am I interpreting that correctly or incorrectly?
I suppose.
Yes, Commissioner. I mean, that's what I was trying to state before, is that it's not so much a matter of that had they gone through the mediation process, that we wouldn't need to know this information as part of a filing in the next rate case anyway. It's just a matter of the information that would get filed would be information that would be agreed to by more of the interveners along with the applicant ahead of time, rather than being seen for the first time in the rate case.
So Mike, my
It
understanding
still needs
is,
to be filed. Sorry?
okay, so therefore the single signature order would be just in the nature of a procedural order, and the procedure being that we're accelerating what would otherwise be issues in the rate case to a mediation in advance of the rate case.
No, and we're not accelerating them issues that are part of a rate case ahead of the rate case. We're asking parties to do whether they believe this. I think what we would be asking is the parties whether they believe that the purposes of the paragraph can be met in the time between now and the next rate case, and if so, whether they would like the commission, I mean, I guess whether they want to conduct that mediation in anticipation of the next rate case.
But nevertheless, you feel it falls within the scope of a single signature order that would cause that to happen, and that doesn't contravene what's in the current order in front of us.
Correct.
Okay.
Any further discussion? Okay, we've got a motion and a second from Commissioner Maestas, I believe. And Mike, take the roll.
Commissioner Fishman.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
The order is adopted by a vote of 5-0.
Okay, here's a controversial one coming up. Jason, please take it away. A resolution designating April as Safe Digging Month.
Yeah, hopefully it's not too controversial. Let me share the resolution itself. So you should see on your screen, commissioners, the proposed resolution before you, with the exception of Commissioner Maestas. It's pretty familiar to the rest of you. It's something we do on an annual basis. In fact, you may be aware of it, Commissioner Maestas. It's basically designating April as a safe digging month, as most commissions in public and pipeline safety programs do throughout the nation. I apologize for getting this on the April 14th rather than the last Wednesday in March agenda, but lo and behold, here it is. I guess I could spend the time to read it if that's the preference, but it's pretty straightforward language. We're just renewing it in witness whereof before this commission on, actually it should say the 14th day of April 2021. As you know, 811 is a big program throughout the whole nation. I mean, it's important to our infrastructure. It's important to ensuring reliable service and keeping individuals safe, especially in a teleworking environment that most of us are currently still adhering to. The communication networking system is compromised when excavators do not call 811 well in advance of their excavation project. And so this is just recognizing that, the commission understands how important safe digging is, and not just in April, but throughout the entire calendar year, and for any project, small or large, you constantly hear our message. I think the 811 number is now 12 or 13 years old. So, in an industry world, it's probably still fairly new to a lot of places, rural locations, but through the commission's support and public outreach on behalf of the Pipeline Safety Bureau and New Mexico 811, we've really have made a lot of people aware of the needs to call 811. I'm even happy and excited to announce that I've had commissioners call me and have asked about the 811 process for their landscaping projects or whatever have you at home. So, Mr. Chairman, commissioners, that's basically what this resolution is doing. It's just an annual awareness to the general public. I will work with our PIO to send out some type of press release acknowledging that the commission has adopted April as Safe Digging Month. April's also, I think, a Driver's Awareness Month, but I don't want to overshadow that. That's also important. So anyway, that's what this resolution does.
Commissioners, any discussion or motions?
Move to
Mr.
approve,
Chairman.
Mr. Chair.
Do we have a second?
Second.
Commissioner Hall seconded. 1 point for discussion. Jason, have the Unsafe Digging Month advocates had a chance to weigh in on this?
I don't think there are any left in New Mexico.
Just check it. With that, let's take the roll.
Commissioner Sandy Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall.
Aye.
The resolution is approved by a vote of 5-0.
Terrific. Jason, communications with Chief of Staff.
Thank you, Mr. Chairman, Commissioners. I just got a few items I wanted to touch on, and then I think we need to spend some time. I would ask in the meantime, while I'm talking about a couple of other topics, Michael Smith, if you could look at your email regarding a Tucumcari case, I may want to discuss it during communications with Chief of Staff, and we'll look for some guidance from you. Anyhow, I'm happy to announce that we've made several hires over the last couple of weeks and have decreased the vacancy rate, including the State Fire Marshal's office, down to around 18%. So we're still on track and filling all of those hires, critical positions that we've been discussing. And so that's good news. I know Utilities Division is happy they're going to be getting and retaining additional economists and other staff members, as we've also filled in some admin support for ASD and in other areas. And so I have been in communication with Mr. Probst about just Chief of Staff matters. So I'm expecting a pretty smooth transition between this week and when he starts with us on Monday. We have also scheduled a Bochum building walkthrough so I can bring him up to speed on where we are for next Tuesday. I would like to sit down and bring him up to speed on what has been accomplished to date, and get his input on anything that we need to proceed or button up, including seating arrangements and assignments, actual move-in date, parking spaces, et cetera, that I've already been discussing with and sharing and keeping the commission updated on. And so, like I said, we should be able to have a pretty successful walkthrough next Tuesday of the Bochum building. That's already been placed on our calendar. So looking forward to that. The only other thing is I wanted to advise the commission that I'm going to be reaching out to you pursuant to Resolution 3-4-2020. That's the resolution which established the Ambulance Advisory Committee there's been a lot of discussion around ambulance and, internally with staff. And we just think it's an opportunity for us to resurrect the committee, if you will, at this time. It's kind of been tabled, if you will, because of the COVID pandemic. So we haven't been able to meet pursuant to the resolution, which requires twice a year minimum. And the reason I'm advising the commission is because it requires me as the acting director to get commission input on possible appointees to that committee. Okay, so I just wanted to at least make you aware of the ambulance committee and why I'm going to be reaching out to you. That's pursuant to that resolution. Go ahead, Commissioner Hall.
Yes, Mr. Chair, Jason, is that one of our resolutions then?
Yes, Mr. Chairman, Commissioner Hall, that is, and that ambulance advisory committee is something the commission established. So it is our resolution 3-4-20.
When did we establish it?
3-4-2020. So March 4th.
Oh, that's the date.
Yes,
Okay.
ma'am. And I can send you a copy ahead of time so you can take a look at it. But it basically allows the Transportation Division Director to appoint 3 members with commission input. I think the word input is obviously there to allow flexibility of me just reaching out to you and discussing rather than making it an extensive agenda item if needed. But if we have to go there, we will as well.
Jason, just real quickly, what are the parameters or conditions for appointees? Can they be operators?
Yes. They basically would represent certificated ambulance services. Those are the 3 members appointed. Let me go ahead and route this resolution to all of the commissioners just to make you aware, and then we can discuss individually. And it has the parameters within it.
Okay, thank you.
Yes, sir. That leads me to one fairly urgent item, and I kind of want to know how the commission and OGC would prefer we proceed. We have an ambulance provider in Tucumcari that is set to expire April 16th. And I will go on record and state that it is, but no fault of staff not notifying them. Just the ball has been dropped in applying their reissuance certification. And so they have since filed for temporary authority, at least to get them through the notice period. I don't expect any protests or opposition. Obviously, they're an existing ambulance service. There is no issues on behalf of staff. But Mike, and I've been in communication with Judy, there's 2 options. Obviously, we could, I guess, consider it during communications with Chief of Staff or General Counsel, and would obviously have to write a letter to the Attorney General's office for a violation of the Open Meeting Act. Or another option, I don't think any of us are big fans of having to draft those type of letters, but another option would be an emergency meeting Friday to give the 24-hour notice and approve the temporary authority that will at least get us through the 20-day notice period. I'm just afraid of not having an ambulance service in Quay County. Mike, can you weigh in on that for me?
I'm not sure what you're referring to with 24-hour notice.
The emergency meeting. I thought we had a 24-hour notice requirement for an emergency meeting, so we could schedule one Friday morning possibly.
No, the Meeting Act has a 72-hour notice requirement. An emergency matter can be addressed. To deal with an emergency situation, it contravenes the notice requirement, so that requires us to follow the procedures to notify the Attorney General, and it has to be the right kind of situation. I would think an ambulance matter is something that could be addressed on an emergency basis, like something like this. So, I mean,
the application has been.
It could be addressed at this meeting.
Okay.
If the commission chose to do so.
That probably would be my preference as well, Mike. I appreciate that. I just, like I said, we'd have to draft that letter, right? I mean, this is an emergency situation though. So the application has been filed, as has the recommendation on my behalf.
So we can Mr. Chair, I'd like to ask Michael a question. Michael, do you mean that we can address it in this current meeting? Is that what you said?
Yes, to the extent that because it's an sorry, I read it as I'm talking, because it meets the definition for an emergency under the Open Meeting Act, it can be addressed in this meeting. Friday would not be sufficient notice to satisfy the Open Meeting Act, so it really doesn't do anything other than give us more time to review it. But the commission could do it at a Friday open emergency meeting. It really doesn't make a difference for the Open Meeting Act.
And Mr. Chairman, Commissioners, and Mike, I will apologize for this abrupt situation, but like I said earlier, it is, staff has been notifying the ambulance provider a minimum of 60 days in advance of when their certificate is going to expire. So, this obviously came after the fact of when we published this week's agenda. So I just wanted to make you aware of that as well.
So, Mike, could we authorize, without looking at the specific letter that is put together, can we authorize the letter and the action, the creation of the letter and the action?
I believe so. I think, like I said, I'm just looking at this for the first time. If Jason wants to present this, or some other member of the Transportation Division wants to present the specific facts, that would be helpful.
So I would just as soon take care of it now. The rest of the commission willing?
Yes, okay. I'm willing.
I see Ted's
Absolutely.
Mr. Chair?
Go ahead, Commissioner Mastis.
There's probably no need to fully read the communication between Jason and Mike, but I think for the purposes of the record, when we do act on this, the action would be to approve a filed application for temporary authority. But for the record, if maybe either Jason or Mike can explain what are the consequences of the expiration of their certificate, number one, and then number two, what are the conditions and parameters regarding temporary authority? What's the duration? When do they have to come back and apply for a full renewal for their certificate? Just some basics, just for the record.
Mike or Jason, if you guys would like me to do my quick usual nutshell summary for transportation, I'd be more than happy to do that right now.
Go ahead, Hans.
Thank you, Chairman. Chairman Fishman, members of the commission, this comes to you based upon the April 12th application of Tucumcari Ambulance Service for reissuance of certificate number 02754 to provide ambulance service. The current certificate of Tucumcari Ambulance is set to expire on April 16th, justifying the emergency motion on this so that we handle this prior to the expiration of their current certificate. NMSA 1978, section 65 2A11 lists the findings the commission must make before it may grant a temporary authority. That the application is one directing public safety, a governmental program, or a specific public event. There is an urgent and immediate public need for the service. The public may be harmed by waiting for the notice period to expire. The applicant is fit and able, and the applicant has a complete application for a certificate pending before the commission. As of today, transportation staff did file their certification and recommendation regarding temporary authority, indicating those statutory requirements have been met. And they recommend that the commission grant its application for temporary authority. This temporary authority by the commission would have no bearing on the position staff would eventually take on the underlying application for reissuance of the certificate, or on the position staff would take on the temporary authority issuing if a hearing is held on the matter. That being said, staff recommends that the commission grant the application for temporary authority so that they can continue with their ambulance service uninterrupted. I can draft an order to that effect based upon the approval of the commissioners.
Mr. Chairman,
Yes, Commissioner.
I'd like to move to approve the application for temporary operating authority by the Tucumcari ambulance provider, subject to 65-2A-11.
Do we have a second?
I'll second.
We got Commissioner Byrd on as a second. Any further discussion? Let's take the roll, Mike.
Mr. Chairman, before we take the roll, I just wanted to put on the record that the basis for the Open Meeting Act, there were the action in contravention of the Open Meeting Act, I should say, would be under section 1015(1)(f), which would be an emergency matter, which is defined by the Open Meeting Act as an emergency refers to unforeseen circumstances that, if not addressed immediately by the public body, will likely result in injury or damage to persons or property or substantial financial loss to the public body. And that requires that within 10 days of taking action on an emergency matter, the public body shall report to the Attorney General's office the action taken and the circumstances creating the emergency, provided that the requirement to report to the Attorney General is waived upon the declaration of a national or state emergency, which is not the case. So based on that and the effect that the citizenry of Tucumcari would otherwise potentially be deprived of ambulance service, which I believe would meet the definition for likely injury or damage to persons, I would take the roll. Commissioner Hall.
Mike, I just have one point to add. The application was filed yesterday, and the 20-day notice period would expire, I believe, on May 3rd, but we don't have a commission meeting until May 5th. So it would be my recommendation to grant the temporary authority until May 5th, when we could consider it on the agenda after the notice period expires.
Judy, excuse me, could you repeat what you said, the first part of your recommendation? I didn't catch what you said.
The 20-day notice period would expire on May 3rd.
Right.
And if we grant the temporary authority, it would probably be preferable to grant it until May 5th,
yes,
which is the date of the first meeting after the 20-day notice period.
And Judy and Commissioners, if I may, could I even ask that that be extended one more week through the 12th, just to give us some flexibility, because we obviously cannot file a recommendation until after the 20-day notice period. So it may not be appropriate to be on that week's agenda, if that's okay with the commission and OGC.
Yes, I just want to make sure that they're granted the temporary authority to a particular date when the commission would be able to consider it. So the 12th is fine, but we should specify it.
Mr. Chair, I'm willing to amend my motion to do just that and extend the temporary authority through May the 12th.
So do you withdraw the prior motion and then?
No, I'm willing to accept that as a friendly amendment, and as long as the seconder of the motion feel the same way.
Third, fourth, yes.
Okay, so we've got the motion with the amendment. Any further discussion? Okay, Mike, now let's take the roll. Judy, thanks for pointing that out.
Commissioner Baseni Aguilar.
Aye.
Commissioner Hall.
aye,
Commissioner Fishman.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Hey.
Okay, Fonz.
We'll interpret that as an aye.
Oh my God.
Commissioners, the vote is 5-0 to issue the emergency temporary authority.
Yeah, anything to create the impression he has a full head of hair.
Come on.
Ouch.
Commissioner
Not
Byrd,
nice.
Hey, coming for Commissioner Fishman.
well, I was going to say I can relate. That's why
Right.
I know these things.
That's right. He can comment about not having hair.
Yeah.
Pot and kettle debate.
Go ahead, Joe. If Joe had jumped in with that, that would have been, bad form.
No, I'm
Totally
just trying
inappropriate,
to dispel this impression by Commissioner Byrd that I'm the scowler in chief. So I'm trying to bring some levity to our meetings.
That's funny. Pointing that out makes you work at smiling so much more.
Oh, God. General Counsel, you avoid these controversies by keeping your face off the screen, but it's time for communications with General Counsel.
I do have hair, and no, commissioners, unfortunately, I do have something to say today. So Commissioner Byrd will probably, take it out on me at some point. But just with respect, I think we've got a couple things. I just wanted to quickly draw attention while I was looking at the email that Jason directed me to. I also noted I had a couple of emails from one of the parties in the 16276 case, as well as John Reynolds, indicating Jeff Albright responded and indicated that PNM did call for meetings on the time of use rates that he describes as well attended. And Reynolds also forwarded me a letter that was sent apparently to Bill Herman with regard to the requirements of the stipulation, asking to establish a new schedule to address the time of use design elements. I was just looking in the case file. I'm not finding that letter in the case file, but it may be in there along with all the other voluminous filings that are in there. So I just wanted to let the commission know about that. I think we had somebody else in the General Counsel who had something that needed to be raised. Is that the case?
Yes, Mike. I have received notice from Fidel and Kevin in transportation that they would like to provide 30-day notice to motor carriers who may be subject to revocation due to lack of financial responsibility. And the proposed date that they have suggested is June 9th, although they stated that June 16th and June 23rd could be done. If you recall, last year, notice was sent out, but then due to the pandemic and the Zoom, YouTube meetings, we could not have the hearing on the date that was scheduled, and we had to renotice it. So we would like to, at this point, make sure that June 9th is going to be a meeting date, because at some point there was discussion that if the June 9th meeting may not occur. But again, June 16th or June 23rd are also possible dates. So with that, I would just like the commission to commit to a particular date prior to transportation sending out the notice of the revocation hearing.
Thoughts, comments? I drifted there, Judy. I've got to apologize. So other commissioners, please pick this up.
Well, Judy, those are open meeting dates, correct? I'm just getting my calendar.
Yes. Although at some point in time, someone mentioned that June 9th may be canceled.
Why?
I don't know. Isaac just informed me that he had heard that he had heard that.
Oh,
Mr. Chairman, Commissioners, and Judy, the only date that I had circled for a possible cancellation was going to be June 2nd, just due to the Memorial Day holiday.
Okay, so is June 9th is a date that we can have the revocation hearing?
On behalf of transportation, yes.
And commissioners, then we will notice it for June 9th.
yeah, that seems reasonable. Mr. Chair?
Yes, Commissioner Hall.
So I just wanted to go back to the news that Mike just provided us. I didn't quite hear the last part of what you were talking about, Mike, wherein you mentioned somebody was asking for an additional schedule or some kind of schedule. Could you repeat that?
Mr. Chairman, Commissioner, I was referring to a letter that was sent by PNM to Bill Herman, who was the mediator previously.
Yeah.
261 case. And this was sent on March 29th, 2018 in case 16-2, referencing case 16-276. And I'm just reading this quickly, but it states that they wanted to coordinate with Mr. Herman on renewed effort to receive input and to develop information relevant to time of use and options for time of use design elements, such as on and off peak periods and seasonal differentials. I look forward to establishing a new schedule to address these issues in accordance with the approved stipulation in the 2016 rate case. So it appears that there was compliance by PNM in contacting the mediator.
And then, okay, so I thought I heard you say prior to that that there had been some mediation meetings held, but that doesn't seem that seems inconsistent with what you just now said. Were there in fact any mediations held?
Mr. Chairman, Commissioner, what I said was that Mr. Albright, Attorney Jeff Albright, and I'm not sure who he was representing at that in the 16276 offhand, did email me and indicated that PNM had called for meetings after the 16276 case, and I assume that was to the signatories, and he reported that those time of use meetings were, as I said, he describes it as well attended.
So Commissioner Hall, just a quick comment is that it's one thing to have held the mediation meetings. It's did they result in anything? And, what have we gone forward with? And I think that we need to do a little more looking at that. I believe Carolyn, when she looked it up, basically felt that there had been no agreement or particular resolution. I'm not sure if that's the case, but I think that was to her knowledge at any rate. So just to make that distinction clear.
Yeah, I think that's an important distinction. That was going to be my next question. Well, if they were held, what happened? And why is there nothing more in the record to reflect that? So I guess my thought is that maybe Mike should follow up on that. And if I have to issue a single signature order to do that, I will.
So,
Mike, what's your suggestion?
Sorry, Mr. Chairman, Commissioner, I was just going to point out that the stipulation, as I said, the stipulation did not require them to make a filing with the commission, only to develop information relevant to be included in their next general rate case. And the order that was the commission approved today has provisions in it that ask PNM to address it's paragraph A2, if PNM took the actions stated above in decretal paragraph A, how many meetings occurred and when the meetings occurred and whether agreement was reached on any elements of the time of use rate design. And if 3 was if PNM did not take the actions stated above, explaining why PNM did not do so. So it does appear that there, from the information we've received so far, that there were actions actually taken.
Okay, well, it sounds like that order covers what we need to do now, which is to get a response from PNM on whether they reached a resolution or at least whatever the results were. If it wasn't a resolution, we'd like to know that too. But so what I believe that order then would require for them, would be for them to respond to us in a short time frame, correct? We were expecting to hear back from them. I don't know if you gave them a time frame. I don't remember what it says. How did they? Can we hear from them soon? That's what I'm trying to get at here.
So, Mr. Chairman,
Go ahead, Mike.
Chairman Commissioner, the original order only required them to conduct a mediation. As I said, it did not require them to make a filing with the commission as to whether the mediation was successful. Obviously, it's a mediation. We can't require them to reach a successful result. What it did require them to do was engage in mediation prior to PNM filing the next rate case. So we could certainly issue a single signature order asking them if they did reach a result through the mediation or not. But it was never a requirement that they actually reach a successful agreement.
Okay, so at this point, do you think a single signature order would add anything to what the current order that we just approved does?
It would only give us the information ahead of the next rate case filing as to whether there was a positive result from that mediation.
And if there wasn't, there's really not much we could do, right?
Yes, that's my understanding.
Okay. All right. I probably won't do, and I don't see a point to doing a single signature order.
Okay.
Yeah. Okay, well, good. We got some information.
Mike, did we finish communications with general counsel, or did Judy have something to add?
Mr. Chair.
Commissioner too much hair.
Not enough. My belt line's going south and my hairline's going north, so there's nothing I can do. I just had a question for Mike. Mike, I understand that the commission used to have a look ahead calendar to better assist commissioners to maybe visit the e-docket and prepare themselves for upcoming cases beyond just the week ahead. And is there any way we can resurrect that look ahead? Because some of these cases are becoming not just complex, but the record is quite voluminous. And I, for one, don't want to solely rely on the RD and any recommended order. I think it's incumbent upon us as commissioners to really look at appropriate, parts of the record. So is there any way we can have at least maybe a month look ahead? Even if it's tentative, you can add as many qualifications as you wish, but I think it would benefit us greatly to build on the progress that we've already made by establishing a deadline for the agenda and attachments on the Friday before our Wednesday meeting. So is there any way that we can bring back this look ahead calendar to give us better insight in terms of what's coming up?
Mr. Chairman, Commissioner, yes. And that's actually, I had mentioned that during when we discussed the 2-year plan that I intended to bring that back. And I apologize that I have not gotten us back on schedule with that, but I will get us to do so.
Thank you. That's all I had, Chair.
Thank you, Commissioner Mastis. So we're on to communications with commissioners, I believe.
Mr. Chair.
Yes, Commissioner Hall.
So I wanted to bring up the issue that I mentioned last week about the letter I was proposed that we send to FERC, and I believe commissioners agreed on. And I drafted the body of the letter and emailed it out to other commissioners last night. So I don't know if anybody's had a chance to see it yet, but I wanted the commissioners to be able to see the text, and if they have any suggestions or any changes they want to make. You know, we have a day to do that. It's due, you know, by close of business tomorrow, but it's just one page, and I just wanted to invite the other commissioners to review it. And if you have any changes, please let my office know, me or Colin know. Let Colin know, or me, whatever. Just let us know as soon as you can, so we can incorporate them.
Mr. Chair, just before you go on, Commissioner Hall, on that point, Jonas and I have looked at your letter. We have no further comment. It's a great letter, and thank you for taking the initiative to respond. I think it's an important topic that we're going to be hearing more about. So thank you for doing that.
Thank you so much. I appreciate it.
Okay.
Okay. So if I don't hear from anybody by, say, tomorrow noon or 2 or something, we'll just go ahead and send it out.
Other communications from commissioners?
Mr. Chairman?
Commissioner Mastis.
I'd like to bring forth a potential notice of proposed rulemaking on Rule 440 to clarify some of the issues that have come to light most recently in the PNM Arroyo renewable energy project. And I know that at least Judy and OGC feels that this is needed. And I think, Mr. Chair, you've expressed some interest in that. So I'm just putting it out there to all of you commissioners, and that if you have any questions or comments regarding that rule and what should be addressed in a potential revision, please let me know, but I plan to bring that forward in the near future.
Thank you. I'm totally supportive of that. And quite honestly, with Robert on board as my new assistant, I'd been thinking that that's something he could devote some time to. I know in the issues that you raised around 440 were the fact that you could split projects up and have some approved in one place and the rest in a 440 instead of us seeing the whole picture. And that's one issue. I think the other issue is there's a lot of pretty good size projects that go through that 440 that are never really formally brought to the commission's attention. And I don't claim they necessarily need to be individually, but I do feel that on some regular basis, we should have some kind of summary about the basket of stuff that will go into 440. So we know the magnitude of it. And quite frankly, there's probably room for some kind of commission approval to a basket of projects that go into 440s. And it's something we should explore. And so thank you. I was going to do something similar next week, but you beat me to the punch. Appreciate it.
Thank you, Mr. Chair. And then just a few more things. Given the statutory deadline for us to complete a rulemaking on the new Community Solar Act, I'm recommending that from a procurement standpoint, we did request some budget adjustment requests to add more funds to our contracts basis to hire outside professionals to assist us to get some of these stagnant or late rulemakings up and going. And so I'm proposing that community solar rulemaking from that procurement standpoint, at least from a priority standpoint, should be at the top of the list above transportation electrification, since we already have plans that are being adjudicated and being reviewed. And then, I was pursuing decoupling, but in light of this ongoing declaratory order case, that's going to push us well past the end of this fiscal year. And so, I think our attention should be fixed on obligating those contract funds in the best possible way. And so I'm recommending that we pursue professional services to assist us in the rulemaking required in the Community Solar Act. I believe the deadline is April of next year, which is about a year. But given all the cases that we have, I believe we should get going on that as soon as possible. And so I hope to be a part of that, not just on the procurement side, but on the implementation side.
Mike, I'll ask a question of you. My sense, and I haven't read the latest version that finally came out of the act, but that it's going to require a pretty significant amount of work on the part of the commission, and this will be a rulemaking that requires a lot of effort, because there'll be a lot of pieces here where we need to resolve issues. And Mike, is that, I don't know how closely you've looked at it, or Jason, maybe you. Am I correct in that judgment? Or you can tell me I'm full of it. I'm fine either way. I just want to know.
No, Mr. Chairman, Commissioners, I agree. I think it is going to be a significant devotion of time and effort to get a rule pushed through. It was an issue, a contentious issue in front of the legislature. It took a number of years to get put through. So I think we're going to have a lot of input from various parties on a rule.
So just based on that, I do think it's personally an appropriate use of those contractor funds.
Mr. Chairman, Commissioners, I will only add that we have already been receiving inquiries from interested parties regarding the Community Solar Act bill. So I agree with Mike. I think that's going to get a lot of attention.
Mr. Chair, it's John.
Yeah, go ahead, John. I figured you'd weigh in.
Yeah, thank you, Mr. Chair and Commissioners. I would like to weigh in. I appreciate Commissioner Maestas raising this issue, and I agree with everyone else that there's some heavy lifting ahead of us on this rulemaking. I just wanted to, I haven't had a chance to ask Jason this, but I was thinking about asking the next Chief of Staff, but I had hoped to present the bill to the Commission 2 weeks from today with jointly with the sponsors expert on the bill before the legislature.
Jointly with what, Ron? What did you say, John? What did you say?
I said I was planning to request time before the Commission in 2 weeks to present the bill or the new law to the legislature and what it involves, jointly with the sponsors expert who testified about the bill before the legislature for the last 3-4 years. So I know he's worked extremely hard on it, and I'm far from an expert on it. And so
that's a good idea.
I thought the two of us could, me essentially to introduce him, but present the legislature and answer questions. I mean, he knows about analogous bills that analogous laws that exist in other states, and could possibly advise us on the rulemaking. So I just wanted to alert you to that, and hopefully the Commission will be interested in this. Thank you.
Mr. Chair,
Absolutely.
John, I think that sounds very interesting, and I look forward to it.
Mr. Chair,
Commissioner Maestas.
if I may, I just have a few more issues. As you all know, we had received notification of potential or alleged improper disconnect notices, and we issued an order, I believe on March 17th, clarifying our original February 3rd order regarding a moratorium on disconnections. And part of that clarifying order directed staff to conduct an investigation of any improper notices or any violations of the February 3rd order. And the report was filed on March 31st. And I just want to just state for the record, I disagreed with the language regarding the general conclusions that utility actions were not improper or in violation of that February 3rd order, and specifically that none of the actions were improper. While it may not have been a technical violation of that order, the way I read the report, at least 3 cooperatives sent out notices to customers implying disconnections would occur on dates that were in fact prohibited. So in my mind, this is improper and does not meet the spirit and general intent of the February 3rd order to this point in response to our March 17th clarifying order. So it was disappointing in that I saw discrepancies between information submitted in response to our March 17th order and what was brought to the Commission's attention by customers. It's important for the public to know that this report is complete and that the Commission has clarified the order and that disconnections are prohibited until May the 5th for co-ops and small utilities and August 12th for electric investor-owned utilities and the New Mexico Gas Company. So I guess just in conclusion of that issue, I reluctantly accept the report and do not recommend further enforcement action. I would recommend that any of the customers that did receive these notices that they file their complaints and see them all the way through, despite some of these alleged co-ops that sent improper notices, despite them ceasing and desisting and changing that practice in response to our investigation. So I just think we should close the loop on that, Mr. Chair, but it's not my desire to call for further enforcement action. I don't know if my colleagues wanted to comment on that, but I just wanted to state that for the record.
Mr. Chair?
Commissioner Hall.
I'd like to ask a question, Commissioner Maestas, which is, do we feel there have been any other subsequent, or do we know if there have been any, if it still remains a continuing problem? And if so, would it make sense to make some sort of public announcements? Actually, Commissioner Vicente Aguilar mentioning public announcements earlier just made me think of this. I mean, it is important for the public to know, as you say, and for the co-ops to know that the public knows. So is there a place for some kind of effort on that way?
That's a good point, Commissioner Hall. What I recommend is I don't think it would be responsible of the Commission just to sit back and wait for the May 15th moratorium expiration for co-ops. I think that we do have some information regarding complete arrearages. It's a mixed bag in terms of the reporting. Some entities are indicating the number of accounts that are subject to disconnection in addition to arrearages, and some entities are just reporting arrearages. And so I would suggest that perhaps we organize a workshop like we did prior to implementing the comprehensive order, the February 3rd order, and get the feedback from the utility companies, for example, back then on the transition period and conditions surrounding the transition period. What I recommend we do now is perhaps do another workshop and get information on from everyone, total number of accounts subject to disconnection. Of those account holders that are facing disconnection, how many are on repayment plans, because this is our way to judge the effectiveness of our own order and to see if in fact that utilities are being proactive. Because I think what we heard during the previous workshop was that you're standing between us and our customer, and that we need to get to work and fashion a repayment plan that is customized to that particular customer, and that well, I forgot the third one, but I think we need to do the same thing. I think we need to gauge how well this is going and to see if in fact that, the third one is utility said, we have no interest in disconnecting customers. And so I think we need to maybe take the utilities to task and show us, demonstrate that your goal, what progress have you made in achieving a goal of having 100% of customers facing disconnection, that they're on repayment plans. And that's why I think perhaps getting this information prior to May 5th would be very beneficial to us. And the information we receive may enlighten us, and we may either want to take additional steps, any additional orders that may amend some of the conditions of our February 3rd order. I don't advise that we do that, but I think that we need to be aware of how things are going leading up to these dates. The May 5th date that allows for disconnections for co-ops. We have some time, the August 12th date for IOUs, that's a ways off, but I think we need to remain vigilant and just see, what impacts exist so far, not just for customers, but for utilities.
I think that's a good idea.
Yeah, hang on a sec. My recollection is that we do have a requirement for follow-up reporting from all the utilities about disconnections, and that's going to be reported. Is it on a monthly basis or quarterly? I can't recall. Judy, you may recall.
I think we kept it at monthly, but we just relaxed the actual reporting requirement. I'm not sure that we changed the frequency, but yeah, I don't know, Judy.
Excuse me, I was on mute. We didn't change the frequency. We just deleted two types of communications that needed to be made on a monthly basis at the same time that they were making their filings in the 2069 case.
And they are still required, though, to report disconnections on a monthly basis?
Yes.
Okay.
But what was not required, there were two requirements about communications, and I'd have to look at the exact order to get the language right.
Yeah, no, I'm just focused on the disconnections that Commissioner Mastis has been bringing up. So
the actual disconnections, they still have to report.
And they have to report that for how long?
I'm not sure. I'd have to look at the February 3rd order.
But the point is, we do have a little bit of information that we know we're getting to track how well they're doing. But I do tend to agree that it's a good idea to, as we approach May 5th, get everybody on the same page about how the commission's going to be looking at this information and using it, and whether we need to make mid-course corrections as a result of it.
And I believe, Mr. Chair, the February 3rd order required repayment plans to extend at least until November 15th, which is the beginning of the LIHEAP moratorium period. And so, I mean, but I think that the ultimate metric is, of your customers that are facing disconnection, how many are on repayment plans? And of the ones that aren't, what's going on there? Because I think on May 5th, come May 5th and after May 5th, we could receive a flood of complaints. I think we've already seen that PNM is taking steps to beef up their call center in advance of the August 12th disconnect date. So we see at least the IOU utilities making preparations for the reactions and perhaps in many cases the discovery that, oh my God, I can now be disconnected. And so I just think that we as a body and as an agency need to be vigilant and take these steps leading up to these disconnect dates instead of waiting until after and then reacting.
Sure. So would it make sense for, say, 2 weeks from now to have that as part of the open meeting? Have that discussion and get that on the agenda, plan for that to be on the agenda now. That would be my thought.
I would think that, I don't know if we can issue a bench request or issue an order asking for that information, because I don't think that we've asked them to report the number of accounts that are facing disconnection. It's a mixed bag. Some are reporting it in addition to the arrearages, and some are just reporting arrearages. So I guess the two requests would be, please tell us, how many of your customers are facing disconnection, and how many of those customers facing disconnection are on repayment plans.
Mm-hmm.
So Judy, that's something we can do. It's something we did something very similar on a very short notice, but I do feel like we need to at least let them know that we want this information in advance of, I guess it would be a public meeting. I don't know what it would be called, but what do you suggest, Judy?
Well, I remember the other workshop actually took a while, so I'm not sure I would recommend having it on the exact same day as an open meeting. And that being said, we could, by a single signature order, require, certain information be filed at least a week prior to the workshop.
Okay, I will do that.
But if you'd like to have it at the same day as an open meeting, that certainly is your choice. But it did last several hours.
Yeah, I agree with you, Judy. Maybe we can have it maybe the Thursday before the May 5th. Does May 5th fall on our meeting? I don't know.
May 5th is an open meeting date.
Okay, so yeah, I recommend that it be the week before, and that would still, I think, give them enough time to provide the information by that workshop.
Yeah, I agree.
Can I include that in the single signature order establishing the workshop?
Yes.
Okay.
And for the workshop, you want to do that the Friday before?
I think Thursday would be better, but I'm open to Thursday or Friday before that May 5th meeting.
Thursday is good by me.
So Judy, I'll work with Judy on this, Mr. Chair, and other commissioners. But I really do feel it's vital. I mean, we raised the public's attention. We took decisive action, but I think we need to follow through and be vigilant all the way through these key dates for disconnections.
Okay.
And just to finish up, I just wanted to thank P&M. They are going to be voluntarily including a bill stuffer, notifying their customers of the emergency rental assistance program. And so I really thank P&M for doing that and encourage all other utilities to voluntarily do that to help their customers, because helping your customers will help you, because I've seen those arrearages and they're substantial. So thank you, P&M. That's all I had, Mr. Chair.
Terrific. Any other commissioner comments? Okay, I'm gonna just make one, which is, we had the article in Santa Fe, New Mexican about Avangrid testimony that came in, and commissioners were asked for comment, and I just wanted to thank all the commissioners for their discipline in not making inappropriate comments about an open docket. And so thank you, one and all.
Mr. Chair, I don't know if it's a matter of discipline so much as aversion to risk-taking, risk aversion.
I don't care, just so long as we don't make any inappropriate comments. Motivation's irrelevant.
Thank you.
And with that, we have executive closed session. I personally need a bit of a break before we go into that. Mike, how long do you think this is going to take?
Sorry, I was muted. I'm not sure. Judy, this is your closed session. How long do you think?
Yeah, I was muted too. I would say maximum 10 minutes.
Oh, okay. Well, in that case, we can go straight into it. And
Mr. Chair?
yes, Commissioner Vastus.
I'd like to move that we go into executive closed session pursuant to 1015-1, print H and 7, to discuss threatened and pending litigation matters.
I'll
second. Okay.
Commissioner Byrd seconded. Mike, take the roll.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Sorry,
She said aye.
I was muted. Aye.
Commissioner Vicente Aguilar.
Aye.
The motion to move into closed session is approved by a vote of 5-0.
So in 5 minutes, let's be signed up.
So Mr. Chair, there is another link, right, to the Zoom.
Mhm.
So we need to go use that Zoom, and then when we're done, we come back into this meeting to adjourn, correct?
Correct.
Mr.
Okay.
Chairman, Commissioner Messis, that email would have been from Isaac and OGC. Yes, thank you.
And
So we leave this meeting open, right? Is that
Yes.
it? Okay.
can we stay logged in, Jason?
Yeah, the Zoom platform, I believe, requires you to log out, and just like the last time we did the executive closed session, however you guys logged out and logged back in. Seemed to work fine last time.
The existing meeting will continue while we log out.
Right.
Okay.
But is it necessary to log out?
It depends on how you're going to access closed session, Commissioner Hall. If you're just calling in, no, just mute yourself so it's not heard.
Oh, wait a minute. Oh, yeah, all right. Okay, fine. I understand. Yeah, you got to log out.
Yep. Thank you.
Okay. 5 minutes. We'll be logged into closed session. Michael.
Yes.
So I just quickly need to do a quick vote to close the executive session and then adjourn.
Well, recitation that the only matters that were discussed in closed session were those relating to discussing the threatened and pending litigation matters. And then the vote.
Okay. Okay, Commissioner Byrd, I think you're on. Commissioner Vicente Aguilar, are you on?
I'm here. Can you hear me?
Yes. So I think we're ready to go. We're back from executive closed session. I'm not quite sure how much I'm supposed to reveal here, but we reviewed the pending litigation matters. And I believe we are ready to close our executive session. And Michael, take the roll.
Mr. Chair, oh, was that a motion?
I'll move it.
Oh, but yeah, let's do the motion, sorry.
I'll second.
We've got a motion and a second. And Michael, now you can call the roll.
Mr. Chairman, I would just recite that the only matters that were discussed in closed section were those pertaining to the threatened and pending litigation matter identified on the agenda, case SC 38227. I'll take the roll. Commissioner Fishman.
Aye.
Commissioner Maestas.
Aye.
Commissioner Hall.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Byrd.
I thought he was here. You on
Commissioner
move?
Byrd?
Aye, sorry.
Oh, there is.
Okay.
The motion to go out of closed session is approved 5-0.
We are adjourned. Thanks all.
Thank you.
See you guys.
Bye.
See ya. Wouldn't want to be ya.